When I separate from my spouse, who would get to stay in the family home? This is a very subjective question based on circumstances, to be fair. However, there are certain parameters that a court will take into account, and as a solicitor then advising a client in that situation, these are the parameters that I refer to and apply then to the situation for my client. If there are young children and let's say one spouse is going to have the main care of those children, and if it can financially stack up, and that's all related again to that spouse's circumstances financially, any maintenance they're getting from their ex, and the level of mortgage, etc., and how much equity and how much profits in that property that the other spouse might have, then it is possible to say that that spouse with the main care of the children, very young children, should stay in that property, and perhaps that property might remain in joint names for a little while, and you would agree when the ex's name would come out of it. If you're sharing the care of your children, so in a sense they're spending equal amount of time with both of you following separation, but you're in the house jointly owned with your spouse and you want to keep that, again, that would be possible. And if the financial settlement can stack up and you can financially afford to stay in that home, then that would be an argument for you to make that you do stay. And your financial affordability is not just based on what income you have, but any obligation there is for your ex to aliment you and any obligation for your ex to aliment your children. So I think in short compass, there's always a possibility that either spouse can remain in the home. It is your matrimonial home, and commonly it's in your joint names. But we look at the circumstances and apply them to how the court, how the law would treat that situation, and give you advice accordingly.